Don't worry. I don't think Justice Carozza will be that mean to you guys. Maybe to me.
He has been to me in my experience too.
Okay, so I've closed all the breakout rooms, and we should have our judges and our clerks coming in shortly. As soon as they arrive, I'm just going to give a few opening remarks, and then we can hop into the hearing.
Okay. I will send out the guys. I will send out the media consent forms after the hearing. So if you guys can get it filled out right away and then send back to me so that I can pass on to Bryn from OJEN, that would be great. Okay, guys. I haven't sent it out yet. I'll send it right after, really quickly. But if you could just get your parents' signature right away and then just get it back to me right away. Thank you.
Okay, we have our judges panel entering the room here, and our clerks. Welcome, everybody. Just wait for everybody. Here we are.
Hello.
Okay. I'm going to give a couple words here and then we'll get going. So thank you very much to our judges, our clerks, and all our participants for joining us today. Our panel today consists of Justice Carozza, who sits on the Ontario Court of Appeal bench, Haley Pitcher, a staff lawyer, and Gregory Ringkamp, a judicial law clerk. We also have Jesse Abel and Aya Schechner, both clerking at the Court of Appeal and who have been behind the scenes helping to facilitate the Charter Challenge since early fall, actually. So thank you very much for being here. And welcome to everybody else joining us through the YouTube stream. We want to start off with a land acknowledgement. We wish to acknowledge this land on which the Ontario Bar Association, the Ontario Justice Education Network, the Court of Appeal of Ontario, and all of us operate. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. Now, one of the many reasons we do a land acknowledgement is really specific to what we are all here to do today, which is interpret the law and advocate for a just outcome. We do this because the laws we are practicing are largely not the laws of this land, but laws which were forced on its inhabitants, a set of rules that they were and are coerced into following. You're all here to participate in a program designed to build legal capacity, to develop skills and gain knowledge about the law. So it's essential that the recognition of this history needs to be built into what we're doing here today. While there are many people working hard to right the wrongs of Canada's history, many Indigenous lawyers, advocates, and scholars whose life's work have gone into fixing these mistakes, we're not there yet. But together we can work towards a more just legal system. So thank you very much for being here. Thank you to Mr. Sean Carozza for advancing legal education in the province, our judges for sharpening these young minds before us, and especially students for engaging with legal concepts typically, and I can't stress this enough, typically only tackled at a university level or higher. So you'll have a chance to ask questions and meet with the judges panel after the conclusion of the hearing. Our judges may offer a decision or choose to reserve. They will also be handing down the Gloria Epstein Award for oral advocacy to the participant that they find to have been the best oralist here today. After that, we'll move into a Q&A with our clerk volunteers from the Court of Appeal. And without further ado, I'll hand it over to our clerks to open court and begin the hearing.
Good morning, everyone, and welcome to the virtual courtroom at Osgoode Hall. My name is Aya, and I will be your timekeeper today. Each side will have a total of 14 minutes for their submissions. And when your team has 1 minute left, I will hold up this sign that says 1 minute left. And then when you're out of time, I will hold up this red sign that says out of time. When you are not making submissions, please stay on mute so that there's no background sounds. Does anyone have any questions before we get started? No? So I will introduce your panel once again. The president of the panel is Justice Carrozza, and he is joined by Justice Pitcher and Justice Ringkamp. And I'll turn the courtroom over to Justice Carrozza. Thank you.
Thank you very much. We have one case on our docket today. The Attorney General for Ontario, Her Majesty the Queen, and Nino Brown. Appearances of counsel for the Attorney General of Ontario, Ishan Kalra, Jobinpreet Dhillon, Dev Desai, Yogia Kalra. Did I say your names correctly?
Yes, you did.
Great. Counsel for Nino Brown, Shreya Chakraborty, Utej Manava, Shrey Patel, and Shivam Suri. Did I say those names correctly?
Yes, Justice, you did.
Okay, thank you. Okay, you know your time limits. We have read the materials. Thank you. We will call on the appellant at this time.
Good morning, Justices. I'll be doing an introduction today. May I begin?
Yes, thank you very much, Mr. Dhillon.
Yes, so as you know, my name is Mr. Dhillon. Me and my fellow advocates will be presenting the appellant in this appeal. Today, we will show that Justice Siddiqui's findings that the conditions imposed on Nino Brown were not in violation of his charter rights under Section 15, Section 11E, and in any situation are found in violation are justified under Section 1 reasonable limits. Our first advocate is Mr. Dev Desai. We anticipate you will hear that the conditions have met the necessary accommodations for Mr. Brown's disability, which can be proven through the two-part Section 15 test. Mr. Brown's disability is recognized by the Crown as an accepted disability, allowing for a distinction based on enumerated grounds. The established conditions and thereby the established distinctions do not discriminate against Mr. Brown and his disability. Our second advocate is Mr. Ishan Kalra. We anticipate you will hear that the established conditions provide reasonable accommodation for Mr. Brown and the safety of the population, along with that the conditions are deemed as a necessity for the safety of the public and are established as least onerous. And finally, our last advocate, Mr. Yogia Kalra. We anticipate will clearly show that the conditions imposed are justified as a reasonable limit under Section 1. Overall, it is our position that the conditions imposed on Mr. Brown were justified as they rightfully achieved a proportional balance between his addiction and subsequent history of offenses and the protection of the public. Thank you, Justices. Now moving on to the first argument presented by my colleague, Mr. Dev Desai.
Just before we hear from Mr. Desai, Mr. Dhillon, what at the end of the day, what are you asking the court to do? Allow the appeal, and what exactly are you asking us to do?
We're asking the court to allow for the conditions to apply on Mr. Brown.
All right. Thank you very much. Yes, Mr. Just looking at the screen here, Mr. Desai, yes.
Yeah, good morning, Justices. My name is Dev Desai. May I begin?
Yes, please.
Thank you. The bill conditions imposed do not violate Mr. Brown's equality rights as a person with a disability under Section 15 of the Charter. It is our position that the conditions have met the necessary accommodations for Mr. Brown's disability. Firstly, step 1 of the two-step Section 15 test helps determine if the bill conditions violate Mr. Brown's rights. This step asks if the law creates a distinction based on an enumerated ground. It is widely acknowledged that alcohol use disorder, also known as AUD, is recognized as a mental or physical disability under the Canadian human rights legislation. Cases such as Hanfield v. North Thompson School District number 26 establish this exact thing, therefore allowing a distinction based on enumerated grounds. The Crown agrees with the respondent that Mr. Brown's condition is a recognized disability under Section 15. Moving forward, the second step of the Section 15 test is simply state, just asks if the distinction is discriminatory. If the bill conditions itself do not worsen or negatively affect Mr. Brown's situation, there's no discrimination. The conditions do not impose a burden. Furthermore, the respondent has failed to prove that the bill conditions imposed resulted in any adverse effects. Furthermore, Condition 3 states that the accused will not attend any licensed establishment that serves alcohol, and Condition 4 states that the accused will not possess or consume alcohol or any non-prescribed controlled substances during the term of his release, except within the confines of his home. It is our position that the purpose of these conditions only limits Mr. Brown's consumption in public, not completely restricting it. And this is significant because it affords Mr. Brown the choice to attend to his addiction. Given Mr. Brown's history of violence, where alcohol was
can I interrupt you for a second? So you don't, can I just get your position on this? So you say it's not an onerous burden if he's permitted to drink at home, but where the condition prevents him from consuming in public. Is that right?
That is correct.
And that's not an onerous burden in your view?
No, because he's still allowed within the confines of his home.
I see. One question I had though is, like, the condition says that, you know, it's a can't consume or enter a licensed establishment. Is that right?
That is correct.
Okay. Wouldn't that really, I guess, Mr. Desai, wouldn't that capture any restaurant, for example? So, you know, something like the Keg or Jack Astor's, you know, or Moxie's, those are all licensed establishments. So isn't it kind of an onerous burden on him that he wouldn't be permitted to enter into any of those establishments?
I mean, at the end of the day, the issue is regarding his alcohol use disorder, and just because he isn't allowed to enter an established license, like that doesn't mean he is not allowed to drink per se. Like he does have the ability to ask someone to bring alcohol to his house where he's able to consume it in a safe manner.
Okay.
Thank you. Given Mr. Brown's history of violence where alcohol was always present, this limitation was necessary to protect public safety as well as Mr. Brown's safety as well. And thus the conditions imposed recognize his disability and balances the protection of society based on his past criminal offenses. Justice, the derivation of the respondent's position that the conditions violate his rights to equality comes from his relationship with his mother. The fact is that Mr. Brown does not want to consume alcohol at home because his mother does not prefer it. And this is strictly outside of the realm of the law. It does not mean that the bail conditions themselves are violating his rights, because the conditions are actually allowing him to consume alcohol at home. Lastly, the state conduct collectively keeps everyone's well-being in mind, and the conditions are set in accordance with this. Mr. Brown's choice not to drink at home, even though he's permitted to, is an option that he chooses, and hence the bail conditions in no way, shape, or form itself violate the accused's right to equality. My fellow advocate, Ishan Kalra, will be speaking next on Section 11. Thank you, Justices.
Good morning, Justices. My name is Ishan Kalra. May I begin? You're muted. Can I begin?
Yes, you can.
All right, thank you. Per our visa, bail conditions must address the specific risks posed by the accused release. So we believe that Justice Siddiqui failed to consider that the conditions granted to Mr. Brown were not only designed to prioritize his disability, but that they were as least onerous as possible. The conditions imposed clearly protect public safety, as Mr. Brown has a history of dangerous and violent behavior associated with alcohol use. Thus, the conditions were reasonable and necessary and the least onerous. It is imperative in a Section 11E analysis to determine whether any need for a condition has been demonstrated by considering the risk the accused would pose if released without conditions. Mr. Brown has an extensive history of previous criminal convictions spanning over a period of 15 years, ranging from drug possession to assault. Over that period, he has also been arrested 3 times for causing disturbance by being drunk. The common denominator in Mr. Brown's criminal history is, of course, his consumption of alcohol. Given the conditions imposed upon him, specifically conditions 3, 4, and 5, Justices, it is our position that these conditions decrease time Mr. Brown is outside, which further protects the public and ensures Mr. Brown can still tend to his addiction within the confines of his home. Were there alternatives?
Sorry, can I just interrupt you for a second? What do you say to your friend's position that he's still allowed to consume alcohol within his home and then go outside and deal with the public?
Yes, so Justice, he's allowed to consume alcohol within the confines of his home, and he knows how he can act in public. So that's why we put limitations on him entering public scenes such as restaurants, licenses, and stuff like restaurants and licensed establishments. So that is why we want him only to drink at home. And if he chooses to go outside, that is still within the limits, and that is still at least owner's condition. And allowing him to do so will basically allow him to be a person and actually live in society. And if he then commits a crime again or something, then after that it will be dealt with.
Okay, thank you.
And another question that may be arising is, were there any alternative conditions that could have been imposed upon short of detaining Mr. Brown? I suppose the respondents may feel that these conditions invite breach given the nature of his addiction issues. However, it is our position that the conditions imposed upon Mr. Brown not only protect public safety, but are extremely necessary to ensure the protection of the public and himself. We can only hope that he understands the nature of the conditions and, despite his addiction, will comply with the law that seeks to impose the lease owner's conditions upon him. It is clear that the judge made these additions with full knowledge of his background and his alcohol use disorder. As the accused's history of criminal behavior emanates from his public alcohol consumption, the conditions were reasonable and the lease owner's forms of release in the circumstances short of detaining him or putting him in jail. So to repeat, as per our visa, bail conditions must suggest the specific risk posed by the accused's release. Thus, considering the law at hand, Mr. Brown's prior convictions, history with the law, addiction, and public behavior, the bail judge had to put in bail conditions that would allow for public safety to be upheld. So I'll now be handing it over to my colleague, Yogi Kaura, who will talk about Section 1.
Good morning, Justice. My name is Yogi Kaura. May I begin?
Yes.
Thank you. While the Crown does not believe that Mr. Brown's bail conditions are an infringement upon his charter rights, we will show you that if an infringement is found, it is clearly justified under Section 1 of the Charter. It is the Crown's duty to show that any state violation of rights prescribed by law can be demonstrably justified in a free and democratic society, with the goal of achieving a balance between the rights of an individual and the best interests of a society. To determine if an infringement is justified, the Oakes test is used. The conditions and objectives to admit a charter right must be both pressing and substantial, as well as proportional to the laws being limited and pursued. The first part of the Oakes test asks whether or not the objective of the reasonable limit is important enough to justify limiting a charter right. The accused's bail conditions were set as an alternative to pre-trial detention, as outlined in Section 515, subsection 10 of the Criminal Code. The accused's criminal history demonstrates a propensity for committing violent crimes when under the influence of alcohol. The conditions protect the public by reducing the risk that the accused will reoffend. The second part of the Oakes test asks whether or not the conditions are proportionate and has two subparts. The first subpart addresses the rational connection to public protection, which is clearly seen through the decrease in risk of Mr. Brown in an intoxicated state by having him drink only in the confines of his own home. Restricting his ability to consume and possess alcohol in public are a rational means of reducing the risk of reoffending. The last
Counsel,
area of
may
proportion.
I ask a question?
Yes, of course.
What's the Crown's position on the facts of this case where the accused actually couldn't drink at home because his mother didn't allow alcohol in the house? So in the facts of this case, is it proportionate that Mr. Brown can't drink at all? And is that proportionate against the Crown's worthy objectives of protecting the safety of the public?
Of course. Thank you for the question. As my colleague Dev Desai mentioned, the conditions inside of his own home are outside of the boundaries of the law. Even though it may be a little bit difficult for him to drink at home, it is not it's not the law's responsibility to address that issue. It's more so a personal issue that Mr. Brown will have to deal with. He can have a discussion with his mother, try to explain the situation, but that is really all that the court can really do. The court cannot take a place or make a decision for the inside of a household. The last area of proportionality is minimal impairment, which questions whether another method with less detrimental effects would achieve the same objectives. In this case, it can be seen that Mr. Brown's life was not greatly altered due to the conditions imposed on him. There are several points I'd like to share. Firstly, the conditions are the least onerous method of ensuring that the accused does not commit more violent crimes while intoxicated, while also accommodating for his disability and providing him opportunities for social interaction. The conditions also cause no significant negative impact on the accused's liberty or health. He is free to pursue an otherwise normal life while limiting his drinking to home. As supported in my points today, there is a clear rationale behind Mr. Brown's bail conditions, as well as the fact that the conditions, as reasonable limits, are justified under Section 1 of the Charter. Thank you for your time, Your Honor.
Can I ask you one question, Mr. Calera?
Yes, of course.
I understand the Crown's position, but how do you sort of look at this particular condition in the context of his diagnosis of alcohol use disorder? Isn't that a concern that this court, and obviously the judge in the court below found it concerning? Doesn't that have a factor? Isn't that a factor that plays a role here?
So I'd like to bring up the idea of deference. And it is clear that in the initial court hearing where the bail conditions were decided, the judge did consider his disability, AUD, and designed the conditions of his bail to surround that, right? So it is clear that he's able to drink. It is clear that he's able to attest to his condition, the condition that he needs alcohol at certain points in his day. And this was done through being able to drink at home. And as I mentioned before by my colleague Ishan and Dev, these conditions were specifically designed for his disability. So I do not agree that they impair him in any sort of way.
All right, thank you. Okay, is that the appellant's submissions then?
Yes, Your Honor.
All right, thank you very much. We'll now hear from the Respondent Counsel for Nino Brown.
Thank you, Justices. My name is Shrey Patel, and I will be doing the introduction for the respondent. May I proceed?
Yes, thank you very much, Mr. Patel.
Good morning, Justices. My name is Shrey Patel, and my pronouns are he, him. And along with my fellow counsel, whom I will introduce shortly, we represent the respondent, Mr. Brown, in this matter today. We ask that you dismiss this appeal on the basis that the respondent's Section 15 and 11E rights were infringed upon, and as such, these infringements cannot be saved under Section 1. First, my co-counsel Shreya Chakraborty will explain that the state action imposed upon Mr. Brown reinforced, perpetuated, and exacerbated Mr. Brown's disadvantage, resulting in a direct violation of his Section 15 rights. Secondly, my co-counsel Shivam Suri will discuss the bail conditions imposed upon Mr. Brown. I anticipate that he will discuss in detail the reasons why those conditions fail to meet several areas of the conditions listed under Section 515, subsection 10 of the Code. As a result, this violates Section 11E of the Charter. Lastly, my co-counsel Yutaj Manava will show that the infringements on Mr. Brown's Section 15 and 11E rights cannot be saved under Section 1, and therefore are unreasonable limits placed upon Mr. Brown's rights. For all these reasons that we will explain in more detail, we respectfully request that this appeal be dismissed. Today, we aim to clearly define the limits to which the Crown may be able to infringe on the rights of its constituents in the interest of preserving public safety. Thank you, Justices. And next, you'll be hearing from Shreya Chakraborty regarding Issue 1, Section 15.
Mr. Patel, can I ask you a question just before we hear from your colleagues? Assume for the moment, and this is just an assumption I want to make for the purposes of this question, that we're not with you in terms of the appeal. Is it your position that we could decide the issue here and now, de novo, or do we send it back to the judge for reconsideration?
I believe that we can sort out the issues in this court today.
So you'd like this court to make the determination if we're not with you?
Yes.
Okay, thank you. Yes.
Good morning, Justices. My name is Shreya Chakraborty. I use she, her pronouns, and I'll be presenting the arguments for Issue 1, Section 15. May I proceed? Thank you,
Ms. Chakraborty. Yes, of course.
It is the position of the respondent that the trial judge correctly found the bail conditions to be an infringement upon the Section 15 rights of Mr. Brown. The legal test for Section 15 is two-pronged. The action taken by the state is an infringement if, 1, it creates a distinction based on an enumerated or analogous ground, and 2, it imposes a burden or denies a benefit in a manner that has the effect of reinforcing, perpetuating, or worsening a disadvantage. The appellant today has conceded that the state action has met the first criterion of the infringement test. When analyzing the contentious issue, the second criterion, it can be seen that it has also been met, especially when looked at in the context of systematic and social prejudices. While it could be argued that the bail conditions allow for Mr. Brown to have quote-unquote free choice, this notion fails to consider whether this choice can truly be freely taken, given the circumstances surrounding his disability. Addiction is a disease wherein the mind and body succumb to the substance, losing effective control over themselves when their needs are not met. Because of the bail conditions, Mr. Brown had effectively two options. One, he could come home regularly to drink and manage his addiction, having to make massive social and financial sacrifices in his daily life. Or two, go about his life as a normal person would, risking major health problems and withdrawal symptoms. The bail conditions imposed upon him not only failed to consider that they make it extremely difficult for Mr. Brown to tend to his disability, but they also failed to acknowledge the extent to which an addiction, especially one like AUD, controls a human being. People disabled by addiction experience disadvantaging and stereotyping, and the Ontario Court of Appeal would agree. As in Tanya, the court stated that, quote, addiction is a disability that carries with it great social stigma, unquote. And thus, by imposing the aforementioned bail conditions, the Crown reinforced pre-existing hurdles to someone experiencing addiction, and also made Mr. Brown vulnerable to unreasonable economic and social repercussions, worse consequences for his health, and even further potential prosecution. In essence, the state action imposes a burden in a manner that has the effect of reinforcing, perpetuating, or worsening a disadvantage. And so the second criterion of the legal test has been met. Thus,
So,
as the trial...
may I ask you a question?
Yes, please.
What do you say to your Frown's position that really the burden's coming from the fact that his mom isn't letting him drink at home, and that has nothing to do with the state's bail conditions? And in fact, the state bail conditions do address his disability because they allow him to drink at home.
The respondent does not dispute, or before again, thank you for your question. The respondent does not dispute that the conditions within the household are outside of the realms of the law. However, despite that, there are many other onerous conditions that have been placed upon him that make it extremely difficult to live his day-to-day life. For example, if he were to get a job, then he would have to come home regularly to manage his addiction, having to make social and financial sacrifices for that. And as such, we understand that the conditions within the household are outside the realms of the law. However, there are still many more issues with the conditions. May I proceed? And thus, as the trial judge correctly found, the bail conditions constitute an infringement upon Mr. Brown's Section 15 rights. Thank you, Justices. You'll now hear from my co-counsel Shivam Suri regarding Issue 2, Section 11.
Thank you very much, Ms. Chakraborty. Yes.
Good morning, Justices. My name is Shivam Suri. My pronouns are he, him, and I will be presenting my argument for Section 2 for the respondent.
Okay,
thank
you, Mr.
Thank you. The right to not be denied reasonable bail without just cause is an essential part of the criminal justice system. It acts as a safeguard for the liberty of the accused persons, which consequently upholds the integrity of the criminal justice system. A denial of fair bail conditions is the clearest repudiation of presumption of innocence. As such, I will point out several reasons as to why the bail conditions imposed upon Mr. Brown are not just and are unreasonable. Bail conditions are set in place to reduce the risks that are outlined in Section 515, subsection 10 of the Code: failure to attend in court, harm to public protection and safety, or maintenance of confidence in the administration of justice, while the risks are specifically tailored to the individual circumstances of the accused. Firstly, the conditions of Mr. Brown's bail conditions are not only in conflict with his presumption of innocence, but also pose a health risk to himself. He is unable to leave his house at certain times of the day, which limits his access to outdoor activities. With the consumption of alcohol only allowed within the parameters of his home, he will suffer serious physical and mental health consequences. Secondly, the conditions imposed upon Mr. Brown are to be proportionate with his potential output of risk, and the bail conditions that do not meet this standard are subsequently unreasonable. Condition 5 is irrelevant to his reason for indictment, and therefore it attempts to mitigate a risk that has a slim chance of occurring in the first place. There is no evidence to support the fact that an incident would occur that late to require a curfew. The time of day has no correlation to his past incidents, and as such, this condition is a breach of his liberties. Lastly, the conditions are to be specifically tailored around the disability of the accused, a criteria that is not yet met for Mr. Brown's alcoholism. The seriousness of his addiction is not taken into account by the bail conditions.
Can I just interrupt you there? Just on the curfew point, isn't the reason why there's a curfew, it would seem to me that a lot of the offenses that have taken place, well, at least this one, the allegation is that it took place in a bar, and generally bars are open quite late. So isn't there some rationale behind the curfew provision? I mean, it's not as if, he's at a bar at 9 a.m. He's at a bar typically in the evening. What do you have to say about that?
Thank you for your question, Justice. To that, I'd say that there are still ways to limit his access to a bar without a curfew, because when you impose a curfew on someone, it can limit your social interaction, say with friends or family, or even requirements that he may have for his workplace. And just being out that late, or by not having that curfew, he can still be prevented to going to bars. And I think that that's something that we would have to work in to his conditions to make it more reasonable to himself.
Okay, thank you.
Thank you. The seriousness of his addiction is not taken into account by the bail conditions. By subjecting him to a restriction on his alcohol usage, it threatens the possibility for his recovery. And in all, the cause of Mr. Brown's bail conditions are to prevent risk to the public. However, for all intents and purposes, they incite further risk to himself and the entities around him. By putting a restraint on his disability, he will become further aggravated and his condition will deteriorate heavily. Due to this, he may be subject to the common withdrawals of addiction, that be aggression, depression, irritability, hallucinations, and other side effects of withdrawal. This will not only further the risk that he poses to himself, but also the public bodies that he interacts with. And you'll now hear from Utej Manava report regarding issue 3. Thank you.
Good morning, Justices. My name is Utej Manava, and my pronouns are he, him. I'll be presenting the arguments for issue 3 for the respondent. May I proceed?
Yes, thank you.
All right. It has been presented that the bail conditions imposed upon the respondent are not in accordance with the principles set out in Section 15 and Section 11E. However, under Section 1, Mr. Brown's rights may be limited if the infringement can be reasonably justified in a free and democratic society. The Oakes test can demonstrate that the infringements are not reasonably justified. First, given that the imposition of Mr. Brown's bail conditions attempt to preserve public safety, the respondent does not dispute that the measures target a pressing and substantial objective. However, second, there is no rational connection between preventing Mr. Brown from purchasing, possessing, or consuming alcohol and preserving public safety, because his condition forces him to physically depend on alcohol consumption or to suffer from the effects of withdrawal. So the measures taken to restrict Mr. Brown are unrealistic, as he will eventually need to purchase and possess alcohol in public if he is to avoid these symptoms. Additionally, allowing him to consume alcohol within the confines of his home does not—
Mr. Manava.
Yep.
Is it your position that if he were to suffer these withdrawal symptoms, he would also be a threat to public safety?
Thank you for your question. Sorry, actually, can you repeat the question? Just so I—
Sure. If he were to suffer these withdrawal symptoms, would he then also be a threat to public safety, or would he not?
Thank you for your question. Due to his past history, it seems that his violent behavior has only been incited when he is under the influence of alcohol. It's unlikely that it would occur if he was facing withdrawal symptoms. It's more likely that he would just feel a bit irritated and be unable to perform his daily functions. It would not incite violent behavior.
Thank you.
And as I was saying, the measures taken to restrict Mr. Brown are unrealistic, as he will eventually need to purchase and possess alcohol in public if he is to avoid those withdrawal symptoms. And allowing him to consume alcohol within the confines of his home does not prevent him from later being intoxicated while in public if he so chooses to leave his home. So the conditions are ineffective and fail to eliminate any hypothetical risk Mr. Brown may pose to the public. Third, the conditions do not minimally impair the rights compromised, because less onerous conditions could have been imposed to pursue the same objective without excessively compromising Mr. Brown's freedoms. An alternative means was displayed in The Crown Against Joy, in which an imposed condition required that the accused to not enter any liquor store, beer and wine store, bar, pub, lounge, or any other business premise from which minors are excluded by the terms of their liquor license. So this would allow him to continue attending establishments that primarily sell food, and he can continue to engage in social activities. Given that this less intrusive measure was available, the measure currently in place cannot be justified. And lastly, the conditions do not have proportionate effects. It's quite clear that the deleterious effects on Mr. Brown are more significant than the speculative benefits to public safety. The measures imposed on Mr. Brown have failed to pass the Oakes test, and it is clear that they have unreasonably infringed upon his rights to equality and reasonable bail. Thank you.
Thank you very much, Mr. Manaya. Does that end the respondent submissions then?
Yes, Justice.
Okay, thank you. I think that we will break in order to consider your helpful submissions. We appreciate you all staying within time. The Court of Appeal very much appreciates counsel who stay within their time limits. And so at this time, we'll break and let you know where we're at when we come back. Thank you very much for your helpful submissions.
Okay, I'm just sending our panel into judges' chambers here. There we go. Well done, everybody. Yeah, huge round of applause. Well done. I'm sure you'll get lots and lots of feedback from our judges, but the way you responded to the judges' questions was just excellent. I've seen a lot of lawyers perform a lot worse when they're questioned or interrupted by a judge. It can really be off-putting. So well done in your responses.
Those were tough questions. I think every single one of those questions was tough. And look, guys, like I said, even in the introductions, they were going to ask you a question. Shrey and Jobin, like both, they asked you a question each. So it's tough when you get interrupted, and then it kind of ruins your flow. But that's why I think at the Court of Appeal, most lawyers, and I don't know, Bryn can probably speak to this, they're trained not to kind of write something down and rehearse it. It kind of has to be a natural flow of your thoughts and a combination of the way you articulate it. But you're high school students. So
and there's also the time limitation, right? Like, yeah, it's difficult when you've got 2 or 3 minutes to say something, and then you're like, now
for mock trial.
I mean, it doesn't use your time.
Yeah,
but,
Justin and I always say the same thing for mock trial, right? It's so hard for these students to be able to operate within only that time frame, and then the tendency is to want to ramble, right? But it's tough. You guys did well. You guys really did well. So thank you for all your efforts. And no matter what the judges decide, it's us versus us. So you're all winners. Mr. S, yeah, comment.
Yeah. I was really impressed how all of you responded to the judges' questions. Those are really tough. Like, even to my experience with mock trial tournament, I think getting a question from a judge, especially in closing submissions, I think a lot of people are not ready for that. And then it really like messes you up, right? But I thought you guys handled all the questions quite well. They were difficult questions, right? This is, these are tough questions that, OJEN are putting out too, right? In these scenarios. And it's not like these issues won't be coming up, right? At the Court of Appeal as well. These are difficult questions, right? And, at sometimes, right, it's judges and lawyers, right? They're making these very difficult decisions. So you guys handled yourself with a lot of class, and we'll see what comes back here with your feedback. I'm really proud of all the efforts you guys put in. I know I've been sort of more on the sidelines with this endeavor, but I'm really impressed with what I'm seeing here.
No, thank you for your support, Mr. S. Appreciate that. Interesting though, hey folks, they asked you, remember we talked about the whole mother, the whole issue with the mother, right? And I knew I had a feeling they were going to ask that, and they asked on both sides, right? So I think Yogia, they asked you first in your section 1 analysis. What do you had to say about the mother? And I thought you handled that question fantastic. And then where was it on Shreya on your side? Yeah. They asked, and again, another a great response. Man, I was thinking to myself, like, I don't know how I would have answered to all those, but you all like just didn't even hesitate. It was fantastic. So
yeah, I would challenge any lawyer to answer some of those questions as succinctly as you all did.
Hey, Bryn, obviously this is kind of our first foray into the finals of the Charter Challenge, but historically have judges, I don't know, like have they come up with a decision right away, or or have they deferred it? What's the pattern usually?
So I'll prep you all for this. The decision that the judges make, in terms like the actual legal decision, isn't really as important as the feedback that you're all going to get.
Right.
Just because, you know, we've written this case, and the case itself is going to have biases, right? So like, I mean, even in real life, that's true too. You know, even the best lawyers don't win every case, but it's even more so in a mock scenario where we've written it specifically. We try to keep it as balanced as possible, but the way a judge rules is going to depend on a lot of factors, not just your performance. So in the past, we've had judges reserve or just say, oh, if I would have ruled this way, but really the finale is about soliciting feedback from actual judges on your performances, on your ability to handle their questions, on your on the strength of your arguments, and not necessarily whether you failed at or succeeded at arguing your case. So just to give you a prep. Now, I've said they can go either way. They can give you a decision, or they can reserve and not give you a decision. But really, but that is kind of the thrust of what the finale is about.
Oh, I think that's perfect, because I think that's what these folks really they always want. They always want the feedback, and you know, how they can improve. And I think that really is important for students to always, you know, want that for themselves, so that in the future, in future presentation, whether it's a presentation or they're doing another simulation, they know how to use that feedback and get better. So that's one thing I love about our students at Central Peel, is that they're always striving for excellence and reaching for the top. And myself and Mr. S talk about it all the time. That's why we love the law program, because the law program, I think, gives them the opportunities to be able to, you know, and Justin also runs a fantastic Model UN program as well. And that just you know, these programs really give these students the opportunity to showcase the best of themselves. And we talk about that all the time. So thank you to OJEN for, you know, for also, if it wasn't for you guys, obviously we wouldn't be here, but we're happy to do it. So anyways,
well
I've been
done to all of
talking
you for representing Peel. The last couple of years, we've had some Toronto winners from Toronto schools. So it's nice to see Peel up on the leaderboard this year.
Yeah, I always see Bloor Collegiate. Luis is up there, and
yeah, he's up there.
He's always up there. So I hope one year maybe we'd be able to compete against them. I kind of in the back of my head, kind of you know, that little competitive fire a little bit wants to. But I was
then
gonna
we couldn't have Justice Carroza as our
as
leading our panel.
I know, I noticed that. I was gonna ask you, Bryn, in terms of next spring. Is there a new scenario coming out for the next for spring? Oh, fantastic.
Yeah, there's a new scenario for spring already. Work underway on that. So stay tuned for that. And anybody tuning in on the YouTube live stream too, we're going to be publishing some details about that shortly.
Oh, that's great. That's great. And of course, some of these students will be also involved in mock trials as well. So we're prepping for that in about a week or so. So doesn't stop.
No, it doesn't, does it? I'm gonna just check with our judges panel because I'm not sure they know how to make their way back here out of the breakout room, and I'll see where we're at. I'll be back right away. Okay.
It's great. Thank you, Bryn. All right, let's hear from you guys. What'd you think?
That was nerve-wracking, sir. Especially the questions.
Yeah. I told you though, did we not? You watched last year's charter challenge. I think this one was way more, they hammered. I think actually who got asked to, Yogi got hammered.
Yeah.
Yogi, you got,
okay.
and you handled those questions, man, with ease, I think. I'm not sure, to be honest with you, I'm not sure if you were right or wrong. I just know the way you handled those questions was, man, that was tough. What do you think, Justice Carosi? He's a bit he can push the buttons, eh? Hey, Mr. S?
Yeah, he's always got the good questions. I always found even in the mock trial tournament, he always would ask questions during those closings, right? So it was good. Like I said, I was impressed that you guys handled those difficult questions well, right? Those are hard. This is what would happen, right? Like, this is basically the process, right? You make an argument and then you have to defend that, right? And I think you guys did a pretty good job with that.
Hey, Mr. S would have experience because you've done your master's. So, those of you who are pursuing higher education, when you have to defend your paper or a thesis, it's very similar. In fact, it's even harder probably because you'll be grilled for like an hour.
Yeah. Well, right? And then I think this process too, right? At here, and obviously if it went to Supreme Court as well, right? Like, that's the process, right? It's like you make an argument and then those judges ask the question, right? It's like high stakes, right? Especially when you're dealing with a charter issue or a charter claim, right? Because if they decide, okay, well, yeah, this law actually is in violation, then they got to make a choice of what they want to do with it, right?
Yeah. And anybody else? Like, how did you feel? Shreya. Did great. Yeah.
Thank you, sir. When we were practicing, getting asked questions in class, the questions were a little more straightforward there.
I know.
So when I was thrown into the situation and I was asked a question by the justice, I I definitely had to think about it for a little bit, but I was very glad that I really went through my part and really made sure that I understood every aspect of it. And I didn't mention the mom on purpose because I knew that wouldn't work out well for me.
Right.
But yeah, that was definitely an interesting experience for sure.
It's also interesting because I felt on your part, Shreya, that I just kind of felt that you were kind of waiting for a question as you were going, and you were like, I don't know, I had this sense that, oh my goodness, I could see Shreya, not that you were nervous, you were fine. It's just I maybe it's just because we were over preparing for one, but I kind of sense, oh my gosh, I think Shreya is really, really waiting for a question. And then finally it came right at the end, right? Almost like your second last, whatever thing that you were going to say. And then it came, and then you answered it very well. And Mr. S had a good point because me and Mr. S have been texting back and forth, but one thing, and this is just already, I'll give you more feedback, but one thing I noticed is when you, and it's not your fault, but when you answer a question, and I think only a couple of you did it, maybe just say after, you could say, Your Honor, can I continue? May I continue? Because some of you answered your question and then all of a sudden you just started, you went right to your speech, right? So just these little things, like, just make note of that for future. Okay. Like when you answer a question from whether, and it doesn't necessarily have to be a judge, even a teacher. Like if you're doing a presentation and somebody interrupts you, you ask a question and then you say, can I continue? May I continue? And then that will help.
Or do they have any follow-up questions to what you said, right?
Right. So that's just a little tidbit, okay, that I noticed. But again, it's a small thing. And I don't know how that might factor into they might probably mention it, they might not, but I think it's worth mentioning to you guys. Okay. But yeah, I don't want to go over too much feedback now because I want you to hear their feedback, and then myself and Mr. S could then if they missed something or that we from our perspective, because we know you more than they do in terms of especially myself. You're all in my class this semester, so we'll hear what they have to say. Yogi, you had your hand up. Yeah, go ahead, man.
I think one thing I realized is that all the preparation really helped. All those calls with Miss Gasper and then the calls we had on our own. It was really good. I'm really glad we did those because like some of the questions we kind of talked about in discussions and we're talking about edits and stuff, like what's important to mention and what's not important to mention. Yeah. And even like the edits and the feedback that you gave us. I mean, that was all really, really helpful.
Do me a favor.
I had it all in the back of my head when answering questions.
Do me a favor, guys. Okay. I'll tell you something. This process that you went through in doing this, that's life. Like that, you should treat every assignment, every task, everything that you do in school, that's the way you have to do it, right? You start, you work, and especially if you collaborate with people, you make appointments, you connect. Like there were some times that, I never, like there was a lot of stuff happening behind the scenes, obviously. Hi,
everybody. Sorry to interrupt. We've got our judges panel coming back in here. Things can be a little bit unceremonious on Zoom when coming and going, but our judges panel has reached some decisions and is ready to give you some feedback.
Yes, thank you very much, Council, for your submissions. We've engaged in extensive deliberations. We're not ready to provide a decision. We're going to take it under reserve, but you'll hear from us shortly in writing. But your submissions have certainly made it a very difficult decision for the court, and we're grateful for all of your helpful submissions. All right, Bryn, we can get into some feedback now.
Yes, Your Honor.
Okay, thank you. First of all, congratulations on the excellent presentation and your participation in the Charter Challenge. I know that you might have some teachers. I see them on the screen watching, and I don't know if any other family or friends are also watching, but at the end of the day, we all felt that it was like actually being at the Court of Appeal hearing an appeal as a panel of three, and the quality of the advocacy was just excellent. What we've decided to do is take you one by one, and you'll each get a comment from members of the panel so that you have some individual feedback. But just because we give you individual feedback, it might be helpful to listen to the feedback that your colleagues are getting, because some of the things that we want to say are probably things that would apply across the board, okay? We're going to go one by one. So for the appellants, the AG Ontario, we had the opening done by, is it Joe? Can we call you Joba or Jobin Preet? What do you prefer?
Jobin is fine.
Jobin, okay. Jobin, you have the tough role here, right? Because you're the first lawyer up on your feet on behalf of everyone. And I thought that what you did was very, very good. You were calm, but more importantly, you provided a roadmap for the court, which is very important for any type of appellant or respondent. And I thought your roadmap was clear. It introduced Section 7, 11, all of your speakers, and it was well done. And you did not show any nerves, for me anyway, and which caught the attention of the court, which is a really tough thing for the first lawyer to get up on an appeal, because you are the first person, and we're all awake. The panel's awake, and they're ready to either jump on you for questions. And I thought that was excellent.
Thank you, Justice.
Haley.
Just to add on to what Justice Carrozza said, the roadmap was really helpful. And one thing I really appreciated is that you didn't just say what topic each of your colleagues was going to cover. You actually explained what their argument was going to be. And so I was already persuaded about why the decision below was wrong and what the Crown submissions were going to be. So it was a great way to make the roadmap an advocacy piece as well. And so I thought that was great.
Greg?
Yeah, I thought it was great. I wasn't sure if you're going to do a roadmap, and I was really thankful that you did. And I thought it was really well done. I knew exactly where everyone was going, and it's not an easy thing to do either. So I thought really well done.
Thank you.
We next had Dev. Dev, you were the first, not speaker, but first lawyer to make arguments. So Haley, why don't you lead off with Dev?
So I was really impressed by how you answered Justice Carrozza's question, which I thought was a very hard question and can sort of take you off of the submissions and not the case when sort of asking about hypotheticals. But you remained calm. Your answer was clear. You brought us all back to the facts of the case and the reason why it was a necessary requirement. And so that was just really persuasive, and it didn't look like it knocked you off your submissions. You went right back to where you were, and it flowed really seamlessly. So that was very impressive.
Thank you, Justice.
Greg?
Yeah, I thought it was excellent. I thought you really came into your own when you were answering the question. I thought your pacing was really, really good when you were answering. And I understood exactly what you were saying, and I thought it was delivered very well.
Thank you.
Yeah, Deb, I agree with my colleagues' comments. One thing that we see at the Court of Appeal a lot is lawyers who talk quickly. And what they tend to do is when you ask them a question, they tend to slow down, and then you have a conversation. And really, I think as a judge, that's where a lot of the advocacy takes place. It's like you're having a conversation with a court. And that's what I got when I asked you that question. And you were really excellent in terms of having a conversation with me when I started to throw some restaurants at you. I was going to throw Sonny's Burgers, but I thought that might be a little too close. Close. So, all right. Thank you.
I don't think Sonny's serves alcohol, Justice Carrozza.
Oh, okay. Well, maybe soon. So Ishan was third, and Greg, why don't you lead off with Ishan?
Yeah, Ishan, you had great energy. It's like one of the most important things for a lawyer to deliver with good energy and keep people engaged. And I was totally engaged when you were going for it. I felt like you really believed in your client's position, which is very, very important. So I thought it was great.
Haley?
Just to add on to Greg, I really like that you started your submissions referring to what the trial judge got wrong, because this is an appellate court. So it's good to ground us in what our role is. And just a general, I always talk really fast when I'm at court. So this is just a general tip that I got from senior mentors, which is to write "breathe" in giant letters on the top of the page and put one point on a page. So you actually have to move your page. I know you had so much to cover in such a short time, but it's something that served me really well. And so I just thought I would share that as well.
Ishan, one advantage you have is you have a very powerful voice. So as soon as you start speaking, you command attention. And I do concur with my colleague, Justice Pitcher, that all you need to do to harness all of that power is to just basically pace yourself and slow down. And it would, that tip is a really good one. I used to, when I was in your shoes, write on a piece of paper up in the podium the words slow down. So I would look at it and it would really slow me down. But once you can combine that, because of your voice is so powerful, I think you've got a really bright future ahead of you on that. Okay.
Thank you, Justices.
You're welcome. Yogia was the last presenter, and Haley.
Yeah, Yogi, I really liked your pace and your emphasis on words. So I was very interested in what you had to say because of the way you were speaking the sentences. And so you had me hooked on what you were going to say next. So that was a really great thing.
Greg?
Yeah, I think we all laughed at your answer. It was really good. Deference is what they always say at the Court of Appeal when you have a tough question or something. And so the fact that you said it was like fantastic. And I think we all just thought that was a great answer. And it fit too.
Yeah, I agree with that. It really did fit. It did fit. We do give deference, but not always. So and if we had more time, I would have engaged you a little bit more on that, but that was a really good answer. So I agree with my colleagues. Okay, thank you very much, appellants. We're now going to move to the respondents. And Shrey, where are you, Shrey? There you are. You were the person that set the table for the respondents. And I thought you had an excellent opening. You had a very, very good roadmap. One thing that I'll suggest is when you're giving an opening, and I know maybe you weren't told to do this for this exercise, but in the future, sometimes we get in advance in your the material. So we got factums, and I'm assuming that you were responsible for writing those factums. Sometimes what you might want to think in the opening is, okay, before you even start the roadmap, you just say, okay, justices, you should have this before you. It's our factum, and here are the various people that are speaking, but the argument, just so you know, is set out in these particular paragraphs. So that's very helpful for us. And sometimes we get a written outline right at the outset, but don't forget to blend your oral advocacy with your written one for the next time, okay? Greg, do you have any comments for Shrey?
I have not too much to add to that. I thought the roadmap was very good. Again, I didn't know that they were going to be given, and I thought you delivered exactly what a roadmap should be. So it was great.
Haley?
Yeah, I'll just add, I really liked after you gave your roadmap, you did a pithy sentence that I don't have it all written down, but you said the issue before is the clearly defining the limits. And I thought that was a good way to frame the judge's mind going into your colleague's submission. So I liked that sort of as a way to end your introduction.
Thank you very much, Justices.
You're welcome. Shreya was next. Greg?
Yeah, Shreya, you had excellent pacing and you had excellent tone. It sounded like you were delivering kind of something just from memory, which is exactly what you want. So I thought it was very, very good.
Haley?
Yeah, I thought it was really great. I thought you honed in on the issue before the court. So you recognized that the Crown has already conceded this point, and you went straight into the second issue and got right into the meat of that issue and didn't shy away from potential weaknesses of the argument. You addressed them. You really answered my question well. You said, yes, it's outside of the law, but, and so it was really persuasive.
Yeah, I agree with my colleague Shreya. Like one thing that I noted about your presentation is you had a very, very thoughtful analysis in your answers. Often we'll have counsel that will read to us or just read their factums, but your oral advocacy, your presentation really had a lot of substance to it, and that was very, very well done. And I thought that the substantive part of what you were saying was well put together. So good for you.
Thank you so much, Justices.
You're welcome. Shivam, sorry. Haley?
Yeah, it was really great. The pacing was really well done. On framing, which I guess is something I really like to get where I am, you started your submissions on reminding the court what the purpose of this charter right is, which is it's the emphasis on liberty, about having bail rights. And so when you framed it like that, we're in the head frame of, oh yeah, that's, we got to make sure it really is a reasonable limit and that this public safety doesn't overtake your client's personal liberty. So I thought you did a great job of framing it, emphasizing on the client's individual liberty and making persuasive arguments to that.
Yeah, Shivam, I agree with what Justice Pitcher has said. You have a very, very good voice inflection when you had to emphasize it. What I'd like you to think about the next time you do this is, using more numbers in terms of your presentation. So if you got 4 points to make, headline them and say, I've got 4 points, because a lot of the substance, what you were saying was really, really good, but it's a lot to take in, right? So consider using numbers or, justices, I've got 4 points to make. Number 1, point. Number 2, point. Number 3, point. And you'll see we're taking notes, and ultimately it might form part of the judgment. So that's what I would suggest for the next time you do that, because you had a lot there to talk about, and combined with inflection and pace, I think that'll really, really sharpen up your argument. Greg, do you have anything to add?
Yeah, you did not get knocked off balance by the question. I thought that was very impressive. I thought you handled it very, very well.
Thank you, Justice.
Thank you. Utej, where are you, Utej? I'm just looking at the screens here. There you are. Okay. Again, one of the more powerful voices that we heard today, and that was very, very good. The one thing that I think that I'd like to point out, because you had the Section 1 argument, and there's clearly a test, right? It would be helpful to go back to what the judge said in the court below and work that in as well with your submissions, because then we can sort of take that theoretical test and see how it's applied in that particular case. So that's a tip that you always want to, when you're in the Court of Appeal, try to bring it back to what exactly the trial judge did. And you had some pretty powerful submissions on a rational connection and answered the question, well, I thought that you were asked. Haley, do you have anything to add for Utej?
Yeah, I'll just jump off of what you said. I really liked one of your phrases. You called the government's sort of public safety concerns speculative. And I thought that was great, because it is the Crown's onus on Section 1 to show that it's demonstrated to be justified. Ugh, my words. So that was a really great way to signal to the court, like, they haven't met their burden. It's speculative. They haven't really shown this. So that was a great point and it was near the end. So it was a great, strong way to end.
Greg?
Yeah, Utej, you had the hardest argument, because I think the judge below said nothing or near nothing on Section 1. So there was really not that much to even work with. I also asked you a really tough question, but I thought you gave a good answer, and I was impressed by it.
Thank you, Justices.
Okay, thank you very much. Bryn, we'll turn it back to you.
Thank you, Justice Carrozza. So we've come to the part of the morning where we're announcing the Gloria Epstein Award for Oral Advocacy. And I just wanted to give you a little bit of context about what this award means. So obviously it goes to the best oralist, but to help kind of inform the award, I want to tell you a little bit about who Gloria Epstein is. So she graduated in 1972 from Queen's University, earning an honors Bachelor of Commerce. She's also a graduate of the University of Toronto Faculty of Law, earning a Bachelor of Laws in 1977. So she founded one of the first Toronto-based law firms that was owned by a woman. She also lectures on the role of female lawyers in Canadian law and her own experience in being raised to the bench while raising 3 children. In 1999, Epstein, then serving on the Ontario Superior Court of Justice, ruled in M&H that the definition of a spouse in the Ontario Family Law Act was unconstitutional because it discriminated against homosexual people. The ruling was upheld by the Ontario Court of Appeal and the Supreme Court of Canada after appeals by the Ontario government of Premier Mike Harris. Justice Gloria Epstein was a co-chair of OJEN's board of directors and a real champion for OJEN programs. Upon her retirement from the board, it was decided that she would be honored with an award in her name given to the best oralist at each and every Charter Challenge finale. So that's what the award means. And back to our judges panel to tell you who's the recipient of this year's Gloria Epstein Award.
Yes, thank you very much, Bryn. It's our pleasure to present the award. Justice Pitcher will name the recipient.
I'll just start by saying this was a really hard decision for us to make. You were all fantastic, and so anyone could have received this award, but we did come to a conclusion, and we would like to present the award to Yogya Kalra. So congratulations.
Thank you, justices.
Well done,
well,
Yogya.
Well done. All right, so Bryn, I think we've come to the part of the program where they're going to be picking the brains of our fantastic clerks at the Court of Appeal, and maybe asking them about their journeys through from high school to undergrad to law school. Take advantage of this. I never had the opportunity to do it when I was in high school, and I would have loved to have done it. I think that you're going to get a lot out of talking to the clerks about law school in general, about your future plans, and what it's like to work at the Court of Appeal. Before Haley and I leave, Haley is a staff lawyer with the Court of Appeal. We're happy to answer any quick question before we turn you over to the highlight, which would be to speak to Greg, Aya, and Jess.
And just before we do so, Your Honor, I'm going to take us off live stream just so we're a little bit more informal and you don't have to be asking your questions to YouTube as well as
right.
a judge on the Court of Appeal. So thank you to everybody who's joined us on YouTube. We hope you enjoyed the hearing, and have a good day. We're gonna let you go now.